Mr. Speaker, is what this bill is all about. Thank you.
Andrew Little.
Thank you, Mr. Speaker. The Victims' Orders Against Violent Offenders Bill is come back to this House in very good shape, and that's a great credit to the members of the committee and indeed to the Labor members on it. And for my colleague Phil Goff has told the House about some of the thorny issues that had to be dealt with, and I have no doubt at all that Phil Goff, a former Minister of Justice himself, one of the best Ministers of Justice we've had in a long time, would have put up a good case, did put up a good case for the sorts of changes that he talked about. That is the nature of Phil Goff, absolutely passionate about this issue, about the rights of people, about an effective justice system and an effective criminal justice system. What a pity the present Minister of Justice, who really is the laziest Minister of Justice we've had in 40 years, does not bring the same alacrity and assiduity to the task that Phil Goff did when he was Minister of Justice. So this bill is in good shape, and it reflects the fact that the practicality of victims' rights, which have really been developed over the last 20 years, is now starting to take shape. Because there's no point in having fine words on a page of a piece of legislation. Actually, it has to have real meaning in real people's lives. So the ability for victims, particularly those of serious violent offending, to be able to take practical steps to protect themselves, this is a good thing. This bill gives important protection to really some of the most vulnerable victims of crime that we have in this country, those who have been the victims of serious and violent crime. It is good that the threshold in terms of the sentence that the offender has received from the court is lower. That is to say, as Phil Goff pointed out, it's not having been sentenced to 5 years imprisonment, but in fact 2 years, because that is when the parole system mechanisms kick in, and there ought to be scope. It's not explicit in this bill, but perhaps a further development is that actually the parole system can be used to effect some of these orders. And of course, allowing an application to be made before an offender, a convicted offender, has been released from a custodial sentence makes sense, particularly when the threats of harassment or the threats of a presence in the vicinity of the victim have been manifest before the offender has been released. It makes sense to be able to make an application before the offender is released. So that is all good stuff, and none of that can be criticised, and it's good to see, as I said before, that the committee has been able to effect sensible change for the benefit of the bill and ultimately for the benefit of future victims, and let's hope that there aren't many of them. There is one important issue left, and Phil Goff alluded to this as well. It's an issue that I think is important, and I noted at the time of the bill's introduction, and I notice it now, and that is the cost to the victim. These are civil proceedings. The application for an order under this bill is a civil proceeding, and therefore the civil rules of the district court will apply. That means, in the absence of anything else, there will be a filing fee. If there is a hearing, and the bill explicitly notes that in some circumstances there may be the need for a hearing, and if there is a hearing, then there will be a hearing fee as well. In some courts, and I am particularly familiar with the employment court, there is a specific basis on which a registrar of that court can waive fees. That is not as clear in the district court, and perhaps something that we ought to be looking at, and perhaps the subject of an SOP when this bill comes to its committee stages, is some explicit provision for a registrar of the district court who has received an application to be able to waive those fees. If these orders are to be processed as it appears on the face of the bill, in some cases on the papers as opposed to having to convene a hearing, then we need to be able to keep the cost as minimal as possible. Likewise, if there is to be a hearing, particularly in relation to a final order as provided for in the bill, since the orders have now been broken up into interim orders and final orders, or at least temporary orders and final orders. If there is to be a hearing for a final order, then let's keep the cost of that as low as possible. So let's have some provision for a waiver of those costs and fees. And so that really is the issue that remains. And if we want these orders to be effective, and if we want victims who are feeling put upon yet again by an offender who has completed their sentence or is about to complete their sentence, and if we therefore want this remedy to be practical and effective, then we need to make sure that they are accessible and that any barriers or impediments to making an application for the order are stripped away. And so the cost factor is an important one. Anything we can do to strip away that cost, that is a good thing. And if it means we have to give registrars of the district court specific and express powers to waive fees, then we ought to do that. There is a cost, of course, in making an application or even in varying, once an order is granted. If a victim then seeks to vary the order, then there is potentially a cost associated with that as well, and indeed in discharging the order if it isn't discharged by effluxion of time or through other means. So let's make this as accessible as we can for victims to take advantage of. And then I just want to conclude, really, Mr. Speaker, by repeating remarks I've made in this House before, and that is, although we have been developing victims' rights in different pieces of legislation over time, and notwithstanding the good work that has gone on in previous parliaments and in previous governments, usually Labour-led governments, the reality is that it is long overdue, and Mr. O'Connor knows it, for us to have a comprehensive, overarching piece of legislation to deal with victims' rights, so that there is one place where victims can go, or their advocates, or those who are assisting them or advising them, can go to say, here is how a victim can respond to a particular set of circumstances. Here is what a victim is entitled to. And the first thing must be an understanding of the criminal justice system. The second thing must be access to an advocate or someone to assist them to negotiate the fraught path of the criminal justice system. Because let's face it, victims don't choose to be in that position. Victims don't choose to be part of the criminal justice system. They are put there because of the actions of another or of others. And it is incumbent on us, and I think we have a moral obligation as a parliament and as successive governments, to ensure that they are afforded proper assistance to work their way through the criminal justice system. So let's have an overarching Charter of Victims' Rights, and let's have an overarching piece of legislation that spells out what victims are entitled to and what they can expect and what assistance they can get and what assistance they will get. And so I think that is very important, sir, and I think it's long overdue for that. And Labour's commitment is we will have that. We will have a comprehensive set of victims' rights rather than sort of appear in different pieces of legislation. The final point I want to make just about this bill is that the practical success of this bill will be in the enforcement of the orders, and therefore a police force equipped to understand the orders and enforce them and be on hand if and when they are breached. And we've seen a recent very tragic case where the protection orders issued by the family court have been, they are breached every day, but where there has been a catastrophic breach of them. We cannot allow that to continue, and we need to know that successive governments will resource our police force to ensure that these sorts of orders will have the backing of the state through the police, that they will be afforded priority, and that people can rest assured that they will be meaningful once ordered by the court.
Mr. Speaker.
David Clendon.
Thank you, Mr. Speaker. Could I just begin my comments by endorsing